This tutorial provides an overview of the certainty of terms and variation of terms by reference to express and implied terms. A contract will only be enforceable if the terms on which the parties have agreed to be bound can be determined with certainty. Certainty of terms. It was noted in Scammell that, as a general principle, it is not the court's role to construct the terms of a contract, and a lack of certainty as to the terms of a contract may result in that contract being held to be invalid. Gaps in a contract can, however, be filled with the implication of terms by statute or by the court where, for example, certain terms are common in the relevant trade or evidenced as having existed in some previous course of dealing between the parties, as in, for example, Hillas & Co Limited and Arcus Limited. The implication of terms will be considered in detail shortly. Pre-contract statements. A pre-contract statement could be mere puff, a representation, or a term. As was held in Carlyle, advertising puff is any claim made in advertising which is exaggerated or vague. As such, mere puff in the form of an exaggerated statement made prior to the formation of a contract will not constitute a term of any contract which is subsequently entered into between the parties. Advertising puff does, however, need to be distinguished from pre-contractual representations. As a general principle, a representation is more specific than advertising puff and is made by one party with the intention of inducing the other party to enter into a contract. If the party to whom the representation is made relies on that representation and it turns out to be false, the innocent party may have a claim for damages arising from misrepresentation. A representation can be distinguished from a pre-contractual statement, which amounts to a term, in that a promise by one party to do something is likely to amount to a term of any contract that the parties subsequently enter into. The consequence of breaching a term of a contract differs depending on the importance of the term and may entitle the innocent party to terminate the contract entirely. Despite the importance of being able to distinguish between representations and terms, it was held in Halbert, Simmons & Co. that there is no singular test, and the manner in which a pre-contract statement should be construed will depend on the objective intention of the parties. The court will have regard to a number of factors.